This question is all about partnerships. And the golden rule with partners in a partnership is that they are jointly and severally liable. So as partners, they all share the responsibilities. So let's look at this. Claire, Dan and Eve, C, D and E, formed a partnership 10 years ago. Now, Claire was a sleeping partner, never had anything to do with running the business. Last year, Dan retired from the partnership and Eve has subsequently entered into 2 large contracts. The first one was with a long-standing customer, Greg, who had dealt with the partnership for 5 years. The second was with a new customer, Hugh. Now, both believed that Dan was still a partner in the business. Both contracts have gone wrong, leaving the partnership owing £50,000 to both Greg and Hugh. Unfortunately, the business assets will only cover the first £50,000 of the debt. So there is a shortfall to cover. And that shortfall, the question then arises, who is liable? We've got Claire and Dan and Eve. Now, we've said that the initial starting point is that partners are jointly and severally liable, but there's a couple of strange things here. So Claire is a sleeping partner and Dan has retired. So that's going to make it a little bit more complicated to think through. Well, for task 1, Claire as a sleeping partner still has full liability for the partnership debts. So she is a partner. Partners are normally jointly and severally liable. The fact that she is a sleeping partner is irrelevant. The law does not differentiate between a partner who is actively involved and a partner who isn't. So if you are a partner in an organisation, you have a certain duty to be aware, engaged and understanding the nature of the business that's going on. So Claire cannot escape liability by merit of the fact she's a sleeping partner. The second task looks at Dan. So Dan has retired. So what does that mean? Well, the situation here is that both Greg and Hugh, so the 2 customers, both believed that Dan was still a partner for the business. So it's important that if somebody is retiring from a partnership, they need to make sure that people are aware that they have retired. So you can remove your liability, but you have to notify people. So it is not true that there's any time limit on this. So the fact that it was more than 6 months is irrelevant. He is liable for any debts or obligations incurred prior to retirement. The word here, though, only, that makes that statement incorrect. So the act of retiring does not relinquish Dan of responsibility. So his liability does not cease on retirement. That leaves us by process of elimination. It must be the 4th option. He remains liable to new customers who knew he was a member of the partnership unless he declared his withdrawal. So the key factor to consider here, does the customer, does the party to the contract reasonably believe Dan to be a partner? Well, Dan was a partner. And no attempt appears to have been made to correct that understanding in the light of his retirement. So yes, he would remain liable to new customers unless he declared his withdrawal. So if you are retiring from a partnership, then you would expect there to be a notification that goes out to customers and suppliers to say, I am retiring, I am no longer a partner, I know that I have been in the past, but from this date onwards, you should not treat me as a partner. And if you don't make that communication, then you can find yourself still liable. Therefore, for task 3, from whom can Greg claim the outstanding debt? Well, we've got a choice of Claire, Dan, and Eve. Well, Eve is the person who entered into the contract, so she must be liable. Claire is a sleeping partner, but we've said the fact that she was a sleeping partner doesn't remove her liability. That was in task 1, so it must be Claire and Eve. And then with regard to Dan, well, Greg is an existing long-standing customer. He still believes that Dan was a partner, so obviously nobody's notified him that they're not. Therefore, all 3 of them remain liable. Eve, Dan, and Claire.